Great. Hello and good morning, everybody. Welcome to the Forte Markets Legal Innovation Journey online. I'm looking forward to keeping our legal tech journey in action by launching our first day of webinars with a keynote speech from the Supreme People's Court of the People's Republic of China. And here we have Yu Chao, who will be kicking this off. This will be followed by a panel discussion that I will then hand over, and this will be on justice tech and embracing change. So I'd like to hand over to Yu Chao now to give his keynote speech. Thank you.
Thank you, the host. Thank you, everyone. And I'm Yu Chao from Beijing, China, and I work in the Supreme People's Court of China. And first, I would like to share a screen, if possible. I'm going to give a talk about promoting modernization of judiciary and a judiciation capacity with advanced technology during COVID-19. And the President Xi tell us we should do a good job in epidemic prevention and control according to laws and regulations, using legal thinking and legal method to carry out work. The Smart Code of China has three basic features as interconnectivity, transparency, and intelligence. Smart Code is an all-encompassing online system for the organizations, documentation, and management of the people's courts, including keeping track of all business transactions, publications, and corresponding legal procedures, as well as providing comprehensive legal services when where needed. During the COVID-19, the Smart Code showed its strength. During the February the 3rd to the June the 16th, 10 million cases were filed by courts nationwide, among which 2.4 million cases were filed online, which is 24%. And compared to last year, the same period, only 1.7 million cases were filed online. So it's an increase of 44% compared with the same period last year. For the court sessions, during this period, February the 3rd and June the 16th, court sessions were 3 million, and online court sessions were 403,000. So it's only 13%. And compared to the same time during the last year, that's 37,000, which means it's a huge increase. You can see the third column is the court sessions online for 2019, February the 3rd and June the 16th. So we can skip this. I don't have to continue to read the numbers and you can see. So how do we get these huge numbers? As to me, I think there are 4 steps as network and litigation-based information technology and internet court and then in-depth application of information technologies. So I would like to talk about the network first. Since 2013, China's Supreme People's Court has made great strides to utilize information technology in all areas of adjudication, enforcement, and judicial management with remarkable progress. Initially, the basic structure of the Smart Code was formed with the establishment of a shared network for carrying out all operations online for courts nationwide. So far, more than 3,500 courts and 10,000 people's tribunals were connected to this dedicated network, through which courts officials can handle cases, work, study, share information with each other. The second is dealing with improving litigation-based information technology so that the Chinese court can provide the general public with effective, convenient, and efficient litigation and legal service by comprehensively employing technological means, including cloud computing, big data, and judiciary blockchain. The People's Court at all levels have established their litigation service centers online litigation service platform, litigation service hotline, and lawyer service platforms, thereby creating an all-around and three-dimensional internet plus litigation service system, and providing parties concerned and lawyers with convenient litigation service ranging from case filing and adjudication enforcement. So let's talk about the third part is e-court, which is also internet court. We have explored the development of digital courts and online courts, provided parties, counsels, and judges with 24-hour and cross-regional service, including online case filing, online exchange of evidence, and online court hearing. By doing so, Chinese court have further alleviated litigants' legwork in terms of information gathering, reducing litigants' travel time and enable the public to save time and gain greater benefits. So during this COVID-19 period, some people do not have to go to the court, but just use the internet court. They can also sue somebody else. The fourth part deals with promotion of in-depth application of information technology outcomes to provide smart services for judges. And we have a platform named Faxin, provides comprehensive and convenient smart retrieval and push notification services to meet judges' precise demands for laws, cases, and professional knowledge when they are handling cases. The smart adjudication system turns litigation material into structured documents, thereby assisting judges in efficiently gathering various legal instruments through data extraction and semantic analysis. The court hearing speech recognition system automatically translates court hearing speech into text, accurately and quickly recording all court hearings. The voice recognition system greatly reduces time needed for court hearing. Accuracy of the speech recognition system reaches 90% or above only in Chinese language, not in other languages. So the last two things I want to talk about is big data platform and the other is surveillance platform. In addition to the smart court system, the Supreme People's Court of China also established a big data management and service platform in 2014. This platform automatically updates data related to cases of all courts nationwide every 5 minutes and collects data from an average of 70,000 to 80,000 cases daily. So far, the platform hosts information from more than 200 million cases and maybe the largest adjudication information resource library in the world, but it's definitely the largest in China. So the last thing I would like to talk about is the supervised by the operation and maintenance management platform. Our smart code utilizes advanced technology to supervise, regulate, and streamline China's judicial process in order to provide a more efficient, effective, and far-reaching service. The wide availability and accessibility of this new system will promote a fair, stable, and transparent environment governed by the rule of law. We hope that this system and platform can provide judicial service and protection for the common prosperity of all countries. And I hope anyone who can offer me valuable suggestions on how China can improve this system and benefits the whole world. And that's all. Thank you.
Thank you very much, Yu Chao, for that fantastic keynote and a wonderful PowerPoint presentation. Sorry, that took a while to get synced up. Now I'd like to introduce the Justice Tech panel, and here we have all of our wonderful panelists. And I would like to hand over to Joanna Goodman, who will be moderating this panel. And yep, take it away, Joanna. just start everyone's videos up again. I think that's everyone now. Great. Have we got everyone?
Lovely. Hi.
Perfect. Here we are, Joanna. Take it away.
Okay, thank you so much. And thank you, Chow. That was interesting. My name is Joanna Goodman, and I'm a tech journalist. The IT columnist for the Law Society. And my book, Robots in Law, was one of the first books about the use of artificial intelligence in the legal profession. Today, I've got the privilege of introducing the first panel discussion of this series. So I hope I can keep you all interested and involved for the next panels too. We've been given some topics, but the status quo has already been challenged on justice tech by COVID-19. And in recent weeks, courts have rushed to remote and online hearings. There is surely no going back, but what does this mean for the future of access to justice and dispute resolution? And what can we learn from the countries that are ahead of us? Well, we've just heard you, Chow, and we have another exciting new court represented here, one in Abu Dhabi. So without further ado, because I think we have a little less time than I thought we were going to have, let me introduce our 5 expert panelists. So I've asked each of them for a short bio and also a fun fact, which is something that's not in their LinkedIn. So it's not something you can find on the internet about them. This keeps it a bit real, I guess. I'm following the order that they are in the webinar program because I'm not sure whether all your screens reflect mine. So we're starting, it's to the right of me, sorry, is Mark Beer, who is in the Library of the Future. He is co-founder of Oxford University's Deep Tech Dispute Resolution Lab and visiting professor at Shanghai University of Political Science and Law, as well as being a member of the Commercial Dispute Resolution Task Force, part of the UK government's Law Tech Delivery Panel, and co-chair of Law Tech UK's SME, Small and Medium Enterprise, Dispute Resolution Platform. And not on LinkedIn is that Mark and Addie have 5 children, and he is 1 test away from becoming a licensed pilot. This is somebody who can travel if he wants to. Then on my screen below Mark is Karen Ray. She has an amazing CV, actually. She started off as a state registered nurse, and then she moved to being a barrister. And after being called to the bar, she was the first combined barrister and nurse in the UK. She practiced clinical negligence and personal injury specialties and latterly practices in regulatory law. And she has been a deputy district judge in the UK civil courts for over 20 years. So the fun fact, she sent me 2 and said that I could choose, but I can't. So I have to say both because they are incredible. So she was an agony aunt on Essex Radio for 4 years in the 1980s. And in 2012, she was due to become the UK's Judge Judy on TV until sadly Channel 5 changed its mind about the concept. I'm wondering if somebody else might want to take that on, if any TV channels are watching here, because it's quite apposite now. Then to my left, we have Christina Blacklaws, who I already know. I'm a big fan of her. She's the immediate past president of the Law Society of England and Wales, lifelong innovator. She set up one of the first virtual law firms and the first ABS, which was a co-op. Christina now advises legal businesses as a consultant and non-executive director, and chairs 2 UK government panels in the law tech space, the Law Tech UK Delivery Panel and Innovate UK's Next Gen Services Advisory Board. And her fun fact, which I must ask you more about offline, is she is a champion at saber fencing. Now, I would never have thought that one, but it's I see the connection. There's something about style and precision there that comes into things. And then on my screen, below Christina, is Sophia Adams-Batty, who also I already know quite well. She describes herself as a non-traditional public policy rebel, a regulator who doesn't like to follow the rules. I find that worrying. Anyway, she is a highly respected policy, law and technology expert and has held senior positions at the OFT, the CMA, FCA and the Law Society, which is where I met her. So we've worked together before and it's always great. She's now spearheading a collaboration of tech, law and policy at Simmons Wavelengths. Now I knew Wavelengths too, and they were the firm that coined the term legal engineer. She sits on the Corporation of London's Law Tech Steering Board and on the Law Tech Ethics Unit, Law Tech UK Ethics Unit, which is also important. Sophia's fun fact is she's watched Back to the Future so many times she could tell you where the edits are. Well, if you like Back to the Future too, we can compare notes because I watched that a lot of times. Because I was writing about it. So I got all the clips about what they thought 2015 should be. And finally, we have Linda Fitzallen, who is very interesting because she brings us another global perspective on justice tech. Her professional background extends from Australia to the US and in the last 5 years to the Middle East, from law firms to in-house counsel and chief executive roles in courts of Sydney and Abu Dhabi. Linda has driven significant technology changes and innovation in the delivery of legal and judicial services. In her current role as CEO of Abu Dhabi Global Market Courts, Linda led the design and delivery of a fully digital e-courts platform with a unique digital courtroom. And her true passion, which completely surprised me, is she likes taking back-to-back rides on very fast, vertically challenging roller coasters. So I think it's really brave because I don't like rides much, but anyway, so this is a brave and adventurous person. So now we've covered all the backgrounds, we're going to jump straight in. We've got a lot to cover. And so I thought we might start in a lawyerly way, says the non-lawyer, and with a definition, because we've been asked to look at justice tech. And there's so much different sorts of it. So I'd like to ask everybody, what do we mean when we talk about justice tech? Who'd like to start? Do we have any volunteers?
I'll give it a go. So for me, it's something that is way beyond the court service, actually. And it's fundamentally about enabling people, usually, or small businesses, so individuals, small businesses, to be able to resolve their problems. And so my interest in justice tech is actually everything that happens up into the court process, although online justice and online courts is a very, very important aspect of this, but I'll leave that to others to talk about that aspect.
I might just follow up on that a little bit, which is, I think, if you look at the role of justice in society, so I take a very philosophical bent to this, and I go back to Plato in many respects and say, what is the purpose of justice in society? It's about that harmony and balance. And if you then apply the criteria that many of us would use from the rule of law perspective around accountability, just laws, open government, accessible justice, actually technology can be brought to bear at any points of those. And it's not just actually at the point where there is a problem to resolve. Justice is about the administration of society in a fair and balanced manner. And that can be from accessing the right schooling, having the right healthcare, through to managing a dispute if it comes about. And I think there's something really important when we talk about the benefits of justice tech and the potential downside to see it in its whole and its entirety, rather than just to focus on disputes being resolved in court.
Perhaps I could go next. I think justice tech, Joanna, is about empowerment. At its core, it's about delivering justice to the people. It's a realization that justice is a service. People forget that. Many judges, obviously not Karen, but many judges forget that they're there to deliver a service to the community, not the other way around. And what technology does is it enables people to get access. And I just want to give you a bit of data. You know, there was a survey done last year, part of the Sustainable Development Goal 16.3, equal access to justice. 80,000 people surveyed around the world. What percentage of people said they would use the court system if they had a serious legal issue? Just 5. 95% of people will not use the system set up by society to help them. So when we talk about justice tech, I entirely agree with Christina. We're not talking about how do we better access the 5%, which is generally the powerful, the elite, and the rich. What we're talking about is how do we empower the 95% to have access to a service to help them solve legal problems. And that's where the public and private element comes in. We cannot hope that the 5% that the justice sector currently fulfills around the world will fill the 95% void, certainly not in our lifetimes. So technology can start to disintermediate between the lawyers and the court systems which serve the 5% in order to deliver access to justice to the 95%. So it's all about empowerment.
Could I come in, Joanna, there? I totally agree with what Mark has just said, in particular in my jurisdiction, which is the county court, where when I first qualified, somebody once told me any particular one litigant, what he or she is suing about, or the company is suing about, will have a knock-on effect within the very structure, the microcosm, if you like, of society that we all live in our towns, villages, and so forth. And so it's terribly important that the knock-on effect can be, as it were, speeded up, can be made more efficient, less cumbersome, less clumsy. But I would just quote the president of the family division, who said on the 27th of March 2020, namely at the very, very beginning of this epidemic, in pushing forward to achieve remote hearings, this must not be at the expense of a just and fair process. So I think that's also got to be borne strongly in mind.
Linda, do you have any comments here?
I do, yeah, and perhaps I'm going to pick up a few themes from the other panelists, particularly with Mark, with empowerment. I think that's incredibly important. And I think what justice tech delivers is a holistic way that people and all people can interact with all elements of the justice sector. So that's with lawyers, that's with courts, both in the criminal and the civil sector. It's about demystification of the process, it's about transparency, and it's about integrity. It's about delivering to people the openness of the system through technology so that they can have comfort and rely upon it in order that their rights, they can pursue their rights and they can be satisfied at the end of the process. So with Karen, I agree entirely. Everybody has to be served, nobody can be missed out, but it is about the simplification of it. And I think that's where justice tech, I believe we're at a crossroads now, particularly coming, we're through, almost through, not quite through, wherever we are in the pandemic, of seeing how that simplification does work for people, as opposed to everybody perhaps making it more complex to jump on it very quickly, and lose those, or lose sight of those incredibly important integers, which is how the public can have confidence in the justice sector. Thank you.
Thanks very much. You faded out a little bit there, or maybe I had thought you faded out a little bit towards the end. But that was fascinating. The thing is, when you're looking at technology, you're also looking at access to technology. So if we're looking at using IT to boost efficiency, just today there was a backlog. There's an article in The Guardian about a huge backlog in the courts. Criminal cases backlog could take a decade to clear, says The Guardian. Do you think that a more efficient process would help to clear that and to bring the cases closer to the people? Because people wait a long time for their cases in court, long after whatever it is has happened. But there's also an access to technology issue. So would anyone like to comment about the efficient processes and speeding things up?
Yes, I'll deal with a little bit of that if I can, from my own perspective. Essentially, with COVID has been quite a lesson for everybody. We got at the beginning a rainforest of papers. I would have 70 links almost every day in April and May. It's gone down a little bit lately, but we're still getting a tremendous amount of links because it's such an emerging process. Essentially, we started with just, we had 4 papers from Susskind, of course, Richard Susskind, helping about how we were going to deal with remote hearings and how that was going to work. We had papers that guided us, for example, on using PDF Expert, for example, on annotating bundles and Adobe. We then got papers on storing bundles at home. It was just massive, absolutely massive. We now, to catch up, if I can be quick, speed forward to present day, what we have now in the UK courts is a promulgation, an encouragement by the court system for us to use something called CVP, Cloud Video Platform. That has been unwound and brought out by the Ministry of Justice, and what would have taken possibly 5 to 10 years has taken just 3 months. And that's coming out. We're all going to get tutorials on how to use that. Skype for Business, including Skype, is also recommended. The Microsoft Teams is out for a consultation because of the GDPR and data protection issues around that. I won't go into it. To some extent, Zoom as well, but Zoom, you do have to tick boxes, so that's slightly safer from their point of view. And then for telephone hearings, we have BT Meet Me, which we're using. But essentially, what's now emerged, literally in the last week, is that we have the following. You can have a total BT Meet Me telephone hearing. You can have a mixed hearing where you've got a BT Meet Me and live hearing. You can have a CVP or Skype video remote hearing, or you can have a mixed video live hearing, and I imagine you can have a mixed video, telephone and live hearing. So when I go to court for the first time in a couple of days, I'm going to be deeply intrigued as to exactly what form it's going to take, and I've got to take all my computer, my phone, all the charging up cords with me and see what is going to happen. What the Mr. Justice MacDonald in the Family Division said way back, what's now way back, the 3rd of April, not that long ago, but it seems like an eon ago, he basically said we now have a smorgasbord or smorgasbord, I apologise to the Scandinavian audience, to choose from in bringing technology in the UK courts to the people. And in essence, we also have the flip side of the coin is the public, who, for example, knows how many people are skilled enough to use their computer, who have a computer even, who know how to deal with this. I mean, I have elderly neighbours and friends who don't really even know how to use their smartphones to the full extent, let alone use a computer and go on. So what we do have, we have something called CourtServe, which is an online listing, so you can find out your case, how it's going to be heard, where and when. And we also have the HM Courts and Tribunal website has got something called Get Legally Speaking. So that's enormously helpful for members of the general public to be able to have access to technical justice. My concern, I'll raise it here, and we come back to it later, is what are we going to do with cases that involve the testing of credibility of witnesses? Somebody, for example, accused in one form or another, whether it be criminal or civil, of dishonesty. Somebody who's being tested in the family courts about their financial background to see whether or not they're going to get the lion's share or otherwise of the property in a divorce. All of these things are historically, for me, as a judge, very important, because I like to see the demeanour of the witnesses and I like to hear the tone of the voice. A number of human interactions, not machine, not AI, not robotic, are, I think, very important in some aspects of court hearings. And I was very interested to hear our Chinese key speaker as to whether or not that was fed into and what impact it had on the smart court in China as well. So it's all really interesting, and it's up for grabs and up for discussion. Thank you.
I think, can I pick up on that though, Joanna? Because what's fascinating, Karen, is that you're absolutely right. There is a sense amongst the judiciary that the demeanour, the sweat on the brow, is a good reason not to be using video evidence for everything. And we had this big debate when I was working in Dubai about whether we should have a witness allowed to come in by video. And fortunately, John Chadwick has actually written, I think, the definitive judgment on the use of video evidence in this way. But more recently, the analysis in the US where they took judges, if you know the one I'm talking about, where they said to judges,
I do, yes.
And the judges said, we have to see the individual, to see their demeanor, to understand whether we should give them bail. Yeah. And these judges have been doing it on average for 30 years, looking at people, listening to them, watching for the sweat on the brow. And they used a piece of AI, and all the AI had was the case file, never met the individual. Yeah. And then they had the judges with the case file and the hearing. Yeah. And the AI was 41% more accurate than the judges. And I think it was Gladwell put it into his book, but the concept was, actually, you can, as humans, we can make an error judgment based on demeanor when the reality is something quite different. And I wonder, are we looking at a hybrid where the AI, in a sense, is one facet of the decision, with the judge's ability then to use that as a guide when looking at somebody, say, over video evidence, if they can't get them in court? I mean, where will it go?
Yes, I agree totally, Mark. And if I may just quickly, Joanna, very quickly, I would say that you've got a situation in court very often where you've read the papers beforehand. You can come to a sort of idea of where the case might go, and it can be flipped entirely when you see the witness. It is extraordinary. I've had it happen time and time again. Never, ever prejudge a case, in my view, in any shape or form till you've heard all the evidence. But I will say quickly, my regulatory hat, I'm doing a lot of healthcare regulatory hearings, and we're going to be going into live witness on remote on that. So that'll be most interesting, because that involves people's livelihood and whether or not they're going to be allowed to continue practicing. So it has very important implications, and I'm waiting and looking with great interest.
Joanna, can I just add one small addendum to this, which is, I think your starting question was whether or not technology could really assist in efficiency, and the answer has to be yes, because what we've got is an incredibly archaic system based around bricks and mortar and burning down the rainforest. Anything has got to be better than that. And technology can definitely catch up with some of the progress that's been made in society. So if you look in the criminal courts, for instance, digital evidence and the way in which technology can help you interrogate that in of itself ought to be now mainstream to help the likes of CPS just get through their huge backlog. It's really, these are very different times from the ways in which our, for those of us that studied criminal law back in the day, might have imagined it being practiced. So it has a place. But there are other considerations that we need to think about. And I think, Karen, you touched on it very briefly, and I do just want to bring that to the fore, which is if we put a global spin on this, and I know that this event is being watched by many all over the world, digital exclusion is a real issue here in the UK. It's a huge issue in the US. It's a really big problem in certain economies in the global south. And we have to think about, when we're designing our justice systems to be hardwired and delivered through a digital capability, which we know, if done well, could really serve society, that we don't do so on the assumption that there is a need for the individual to put themselves right in a position that allows them to be digitally enabled. It's incumbent upon those in the justice system and those in governments across the globe to ensure that their citizenry has access to these very systems.
Christina.
Yes, just to pick up on that, because I think in the UK, the latest research evidence is that there's over 11 million adults who lack basic digital skills. But I wanted to focus on two issues. One is about bias, and one is about the need to be comparative here. So, and they both intersect. So of course, what we know is we have systemic bias in our society, which is reflected in our judiciary and any other decision-making bodies. And so we know that actually we don't have a perfect system at the moment, even in relation to the decision makers, let alone the processes by which decisions are made. And I think that's an important context for us to have. You know, this is not a counsel of perfection. Nonetheless, when we start to look at implementing technological, or particularly AI solutions, we face another very serious problem, which is about embedding those biases, in effect hardwiring them into future decision making. In again, another context, there's a lot of research which evidences that human beings are not very good at being able to question or countermand AI or any computer-based decisions. There was a lot of evidence in relation to the UK police forces in that regard. So to look at those broad issues here, we don't have the counsel of perfection, but we must make sure that we don't embed that into future decision making, and that is an absolutely global issue.
Yeah, I mean that's something that actually made me think when we were watching you Chaz's presentation, when they said they did voice recognition. I'm like, oh, what if two people sound the same? This, you know, could it make a mistake? Could it mistake one person for another? Because after all, we've got the famous AI picture with the Chihuahua and the muffins looking the same in a photograph. So people can sound very alike. And you know, you could confuse things. And there's also, I also concerned about Sophia's point where she says about people not having access or digital skills, but it's also bandwidth. Like we had at the very beginning of this, if somebody's got a legal issue, and they've also got maybe 5 children using the using their system, they might have trouble chunking their way through a lot of complicated systems. So this is, we've already got 3 questions. Let's have a quick look. So
whilst you're looking, again, we mustn't throw it sort of out on the basis that it's not perfect, because as Christina said, it's not perfect now. So more people have difficulty getting to a physical court, I would wager, with children at home, with a job to hold down, than people getting access to justice on their mobile phone. I think that's got to be a fact. More people have access to the internet than they do to justice around the world. I think that's a fact too. So we look at it on the basis that we mustn't let the best be the enemy of the good. And if the system is getting better, and if there's a mechanism to deal with the minority that struggle with internet access, maybe they can physically attend at court if they want to, if that's easier for them. But the vast majority of the population, and this is where I think the private sector will start to disintermediate the courts, want justice delivered at their convenience, at the public's convenience, and that's in terms of time and that's in terms of place. They don't want to fight. They don't want to have to draft a witness statement. They don't want to have to get involved in legalese. What they want is effectively a conciliated outcome, which leaves both sides feeling that the matter has been resolved in a way that allows them to move forward. And that's, I think, where technology plays a beautiful part now, whether that's human conciliation or whether that's an AI-driven asymmetric conciliation, which actually the sort of under 20s much prefer. We've got to make this available to people as an option. That's not to take away people's ability. Ultimately, if they want to have their day in court with their, as I think judges tell me, a Tesco's bag full of papers, if they want that, they absolutely have to have the right to do it. But if the other side doesn't want it, then they should have the ability not to have to give up days, not to have to get and travel and park and find the frustration of waiting for their case to be called, or the judge hasn't come in that day, so it's been moved on, or the other side hasn't turned up and they have to go away again. All that should be taken out of justice. And that's where the efficiency comes in. 29.2 million cases backlogged in India, 100 million cases backlogged in Brazil. The Guardian report suggests we've got our own problems in this country with backlog. We can't just apply the same old rules and hope it will solve the problem. We've got to find smarter ways of delivering justice at the point that the community wants it. And that is generally in an asymmetric manner, conciliated outcome on their mobile phone.
Yeah, Mark, Joanna, could I just quickly say that absolutely, totally agree with that, Mark. And I will say one word, money. What the government has to do, and all the senior judges are saying it by their emails and by their discussions, this court system in the UK has to have money thrown at it by the government in a sensible way, of course. We deeply need resources. There are some being already, as it were, rolled out within the family and criminal jurisdictions because of the vulnerabilities of the customers, if I can call them that, in that environment, children, people detained and so on. But what we have, for example, in the county court, not so much the High Court, because again, resources are being thrown there. At the lower level in the county court, we have almost no resources or very few. And what has happened is we have got to, as judges, go in, even for remote hearings, we have to go into the courtroom. So I have to travel, and would have had to have travelled, as the full-time judges did, throughout March, April and May, to court in order to have remote hearings effected through CVP or Skype or whatever. And the reason for it was simple. It was this: the court files, they are cumbersome, they are huge, they are often misfiled, they're untidy. And what we really need to concentrate on above all else at the moment are e-bundling, e-bundles in the court, getting everything computerized in the court system. Otherwise the public, if we're asking them to go and become computer savvy, then that's a complete waste of time if in fact we're going to have to muddle through on live hearings because the court file system is simply not modern enough. So that, really important, we have to bear in mind. And I imagine that other countries who have got this system up and running, including China, the governments there may have actually effected some form of money thrown at the system so that it could actually be properly developed. That's what we need, very much so, in the UK. Thank you.
That's interesting. Thanks, Karen. Talking about making it work, can I quickly ask? Oh, you were going to say something, Christina.
I was just going to add that I think that everything Karen said is right, and we need to reimagine access to justice. What, as Mark was describing, the key factors which are important to individuals and to business. He described, I'd add one thing, which is speed. Most businesses and most individuals would rather have a speedy resolution, whatever that is, so that they can then move on with their lives. And the way that our justice system, our court system is set up is really is so counterintuitive to speed of resolution. So I'm really interested, as I said before, in justice tech outside of the court system, so that most of our problems can get resolved, and taking into account the broader policy issues that Sophia was talking about. But so you can really not have a situation in a country, even in our country, where 60% of people don't even go to see a lawyer if they've got a legal problem.
So can
we have had $1 billion, Karen. There's been $1 billion allocated on top of the general budget for Ministry of Justice and HMCTS. Another $1 billion allocated for technological reform. I mean, it's vast amounts of money. It's not. I don't think it's the money, because also efficiency drives down cost. So how many people would be reallocated within the government if we had an efficient ministry and efficient HMCTS? When we did an analysis, a court that has 5 staff per judge is generally pretty efficient. Some of the most efficient courts in the world have less than that. I'd hate to think how many we have in our country. I did an analysis in India, and it was over 40 staff per judge. So when you just do those simple metrics, and they're not conclusive, but they're a good indicator, we're enormously overstaffed, we're desperately inefficient, we don't use technology very well, yet we've thrown money at the problem. So I suspect it's about reallocating the resources that we've got, cutting back on inefficiency and cost in order to deliver what justice is about. And justice is about helping people, as Christina said, get the right answer, get it quick and get it cheap. And the key to it are the judges.
Absolutely.
Any court system that thinks that the administrator should be running it will fail. It has to be judge-led with the community in mind. That's my experience.
Absolutely, and it's the paperwork from the judge's point of view that we need to get modernised. That's really where a lot of the money needs to go. Totally agree, Mark. Yeah, absolutely.
So can we learn at all from the commercial dispute resolution, like eBay and Alibaba that we talked about, and commercial organisations in the justice tech? Because as I know Christina and Sophia know, we've done a lot of hackathons in justice, trying to find solutions using apps and AI. I would sort of say to Mark that most people under 20 are not looking for lawyers, but they will when they get to be older, and they're that generation. But do you think that we should be learning from the commercial operations that have got to make things work to be as successful as they are?
I think probably if I start at a policy perspective, and then I know Mark and others have deep expertise and hands-on experience in some of these systems, which is in the best designed policy environment, you would look to anywhere for lessons learned. And I think if you look at just the sheer numbers of disputes resolved in Alibaba's platform and the way in which eBay are managing theirs, and of course their raison d'etre is very different. It's about brand, it's about profitability, it's about keeping their clients with their customers with them versus moving them away from their platform. So it's very user-centric in that way. And if you just pull apart the limbs of that, the principles are absolutely applicable. So I think another way of characterizing what Mark said earlier, and something I talk about frequently, is user-centered design. Think about the user, put them at the heart of everything you do, and that way you wouldn't necessarily exclude those who are digitally limited in access, for instance, because you give them options. You wouldn't make it look, so one of the questions, interestingly, in the Q&A flagged that the interface at the moment is pretty poor in many of these systems. Actually, if you put the user at the heart of these things, you think about the look and feel, the user journey, the questions they might ask, the language they would use, the tools that they have at their disposal, and how you'd interface those. And some of the commercial platforms that have started to use technology to resolve disputes or just manage client relationships absolutely have lessons learned. There's a whole different bag of questions though around transparency and openness, and whether or not you get real lessons learned and how you plug that back in. But that's a separate set of questions. But I think from a policy perspective, absolutely we should be looking at these examples for where it's being done well.
And we had a question here that Mark's answered privately from Duncan Eady about the user interface not being compelling, but it's also being, well, he said, make it simple and approachable. And for all these people who do not have access to justice and who may not have a lot of legal they may have a problem and not have legal knowledge, that's where we could learn from the commercial enterprises that have to do this, otherwise no one will use it, rather than looking at a lot of public money. I wonder if we can look at where we're learning from elsewhere. For example, in Abu Dhabi, Linda, where you've got already Eid courts and it's already set up with technology. Were these your focuses when you were designing it, and what sort of benefits have you seen? And also, if there's any challenges that you can think of when you do have that kind of efficient system.
Yeah, no, absolutely, Joanna. I was thinking, particularly as Sophia was speaking, that a lot of what you said had resonated with how we approached our system. So we have the luxury, and it is a luxury. So listening to you all with this massive caseload, we did not have a caseload. So being brand new courts, only 5 years old now. So what we were able to do without having to put square pegs in round holes, if you like, was to challenge every single aspect of the way a case is handled in a court and work out whether or not there's any reason to continue with that. So that's how we started. So we have a holistic digitalized service so parties register, there's e-filing, so everything is done from e-filing. We have an electronic court file, so picking up what Karen said, with large volumes of documents being delivered and court files. Our judges are not in Abu Dhabi, they're all around the world. So they come in on their judicial portal. We do not need to send them anything, and they are able to access that court file. So are we in the registry, and so are the parties. So they access the digital court file 24 hours a day, 7 days a week from anywhere in the world. That saves enormous amounts in terms of time, cost for parties, for the court, and for the clients, lawyers, enormously. So we continue on with that with video conferencing for hearings or in-person hearings if necessary. I would just pick up the point earlier, is that the system needs to be flexible. The computer cannot say no, because there are too many human elements that are intervening into this process. So the way we tried to conquer that was that on each aspect of the court's journey, we consulted with the profession, and in-house counsel, with clients, and literally with staff here, to see whether or not it was intuitive, or it was an obstacle, it made sense, and to see whether or not we had, if you like, demystified it from what I was picking up what I said before, so that people understood why they were doing something, or why there was a rule to do something, not which was, do you know what, we've always done it this way, the court needs this because this is the way we've done it. So we conquered that, and so we were able, in a consultation phase with every single aspect of it, we were able to remove all those obstacles that have existed before. And I had come from a court with very decent caseload, 40,000 cases, so per year. So I knew that there were those obstacles there, but I think Mark mentioned that the judiciary is key as well. I completely agree with that. We did not cement anything in place until the judges were happy with the way it looked, it felt, and it ticked for them. So picking up on the challenges, we had to, if you like, meet everybody's expectations and meet everybody's requirements. So we really, to compromise, there had to be some compromise along the way, but not such that anybody felt that there was a transparency issue or integrity or really reliability with the system. So yeah, so we have also, our rules have been changed so that we don't have physical, after the case commences, we don't have physical service of any document, because the moment a document hits the court file, the parties get an SMS and an email saying that there's activity on the court file, and from their mobile phone, they can go directly to that digital court file. So that, you know, even for, you know, for people, self-represented litigants on their mobiles, and this is a very digitalized community here, the government has massive plans and a massive strategy for all aspects of government to be digitalized, particularly in the 2030 vision. So, you know, a self-represented litigant on their phone can go into their page on their digital court file. So, but as I say, we've been privileged and lucky to have greenfields. When you have greenfields, you also can't squander an opportunity to test every aspect of it and make sure it works. So, but yeah, I think the challenges are, we felt a very deep sense of responsibility to change things because we could do that. So trying to ensure that we changed it for the right way and not making the us serve the electronic side, the computer, but that it serves us and it serves the whole community in the justice system. Thanks very much, Joanna.
Linda, what was your inspiration? Because you were starting from nothing. What was your inspiration in creating this? Where did you start with the system?
I come from the New South Wales Supreme Court, so we had gone quite a way. Australian judicial system is quite highly digitalised. So I had that kind of background, but I knew also with a legacy of cases where the pain points were. So the inspiration, so I immediately started, my slate was like, okay, these are the pain points. I have to deal with those. But, you know, I have tremendous management here and government support for this digitalization. So, you know, the inspiration was no stone left unturned, no question not asked, no person not consulted. So, you know, it was, it took us 3 years, 2.5 years to build it. It wasn't overnight and we didn't want to rush it. But really the inspiration was every single pain point had to go. And that's how we worked our way through, and with some very creative people who were tested that user journey from all of the players in the system. Thank you.
You did yours, Linda, with Microsoft, right, as the back of house?
Yeah, we did, and all on the cloud. Yes.
And you see, and that's what we come back to Alibaba, right? Who built China's court of the internet? Who did the technology for the court of the internet? Alibaba. Why? Because I think even the Chinese courts, with their enormous wealth, knew that to try and design a future court aimed at internet commerce, one of the best players to do that is the largest online retailer in the world. So it was that collaboration. Now, no one's suggesting that because Alibaba helped to design the technology, it's in some way biased. No one's suggesting that the courts didn't test it. No one's suggesting that the Supreme People's Court hasn't carefully considered it. But why is it so widely acknowledged as being such a sort of inspirational court for an online environment? Well, because ultimately one of the leading technology players in the world in that space helped the court to design the product. And if you look at Alibaba's model now for dispute resolution, which is the gamification of disputes, where customers sign up to be judges and they score more points depending on how close to the consensus they are on resolving consumer issues. So people are proud to be a judge and proud of the scores that they get from being a judge and getting the right answer. We start to see not only how the court system can learn and adapt, and this combination, as we heard in Abu Dhabi, which was a fantastic venture between government and judiciary and Microsoft. But we're also seeing how the gap can be filled at a consumer level by the gamification of the resolution of disputes to a effectively conciliated or determined outcome.
That's very We can all
Completely, sorry, Joanne, if I could go in there, I completely agree with you that conciliation is the way to go. What we need to do more of is introduce these online platforms where people go in, the Alibaba model all over the world is they can go in and they can help themselves in intuitive systems that serve them, because if they can do that themselves and ease the pressure off judicial systems, government resources or whatever, that is where we need to go, and they're happy. They leave the system happy because they've been responsible for the resolution of it themselves.
So can I turn to Christina about the innovation in this, because you're very involved in justice tech and innovation, and a little bit about what we're doing here about that.
So for our attendees who are not from the UK, very brief history. Over 5 years ago, the government took away great swathes of what legal aid, so the ability of people who didn't have money to be able to get legal representation in this country in lots of big areas like family, housing, social welfare. And they undertook to have a review of that 5 years on. And as part of that review, the government has acknowledged that this has impacted their previous decisions, impacted access to justice, and therefore have put together a fund to look at innovation in supporting access to justice. And I sit on a government panel which is tasked with the thinking around how that fund should be used. And there was some research done by the Law Society recently, which evidenced, as we all know, and somebody there's something in the Q&A about this, that obviously the B2B law tech development is way ahead of the B2C stuff, and justice tech, access to justice technology is right at the bottom, because it's very difficult to commercialize it, to have pay points which are acceptable and accessible for normal people. So the fund is really looking at what is a massive untapped market for that accessible, affordable, flexible legal services. And we're looking to bring together the tech sector, the third sector, so all the not-for-profits and charities that are working in this area, and try to provide some blueprints for how sector innovation might happen. So harnessing the power of the burgeoning law tech community, and looking to really focus some of that energy on the access to justice issues. And in many ways, it's very tantalizing, because almost in a sense you can smell, you can touch, taste what needs to be put in place in terms of really simple bots that help and support people to go through a decision tree to resolve, hopefully, their issue, and if not, then to triage them into support, whether that be pro bono, so voluntary help and support, or if they have access to funding, then perhaps through either government supported lawyers or through insurance or whatever, so that they can get the right level of expert help at the right time. And there are a number of things that are being developed and now tested out in this area. And another partnership I want to talk about there, just to mention, is that public-private initiative. So you've got the third sector, you've got law firms and law businesses, and you've got government intersecting and working together to try and find the right solutions.
Joanna, can I just add one final addendum to that, which is I think whatever combination that we go for between private and public sector partnership, there is something, and I would like to come back to that opening comments I made around the rule of law, that actually, particularly in a common law system, that intelligence and insight you gain from understanding what's happening in the dispute space really important that we find ways to harness that, because it's only through that that we move regulation, legislation, protections, or liberalisation of issues that might be causing a problem that need not exist. Because otherwise you end up with a bit of a kind of dark web version of reality operating to one side, and the rest of the framework in which people are operating isn't informed at all. I'm not saying that you can't do that through a public-private partnership, through private platforms of dispute resolution particularly, but they need to be built in principles of design that allow for that intelligence to be fed back into the system, so we do get continuous progress and improvement for the system as a whole. Because the ideal actually is people don't end up in disputes, that they know their rights up front and that those rights are adhered to. And most of the time you'll find that when rights are infringed, it's probably out of ignorance rather than actual intent.
That's true, and a lot of law firms are working with public and private partnerships too. Just coming back to Christina's interesting point about the law tech community, because I know of a few, particularly in family law, where they are working with universities and with government organisations, knowledge partnerships to pull these things together. So one of the things that I think has been enhanced by the pandemic, which has pushed Richard Susskind's book almost into reality, is that we don't kind of step back from it. And I was going, we've got just over 10 minutes left. So what I wanted to move to is, we've made all this progress in the pandemic, perhaps towards a little of what Linda has achieved, a little bit of towards what's been achieved in China with less AI making decisions for us, perhaps. I wonder, looking forward, the post-pandemic environment, what lessons do you think that we've learned? What will we keep? And what are the biggest challenges we have looking forward, not to slip back from progress again into the slow speed of legal technology, which has suddenly really sped up a lot. So I'd like to get something from everybody about the future before we finish. So who'd like to start with some predictions?
I can look at my crystal ball first, if that helps, Joanna. So look, there's the optimistic version of my crystal ball, and then there's the realistic version, and I'll do realism for brevity of time, which is, I think what we've seen as a proof of concept has been absolutely proven. So all those naysayers that said, oh, that can't possibly work, or it'll take ages, and can't possibly convince people to go online, actually too late. But already done, slam bang, in the bag, sorted. So I think that proof of concept, which probably otherwise would have taken, I don't know, another 5 years or something, we've got over that. Now, there's two Achilles heels, though, to this, which is, one, there is a general desire in society, and this isn't just defined and limited to the justice sector, to snap back to pre-COVID, because we want to get back to normal, this whole kind of back to normal conversation. And part of that actually is to get over the trauma of what has been and still remains a very difficult time for people globally. And there is a desire to want to go back. And I think that elasticity kind of response needs a degree of leadership to restrain it where it needs restraint, right? So we need the judiciary at its height to really say, actually, why are we going back to that? Or are we just doing that because it's a comfort blanket? And the other Achilles heel is resources. And Karen said it earlier, and others have mentioned it also, that I think the realist in me tells me that the public finances are just about broke, and it's going to be a really difficult climb out of what the biggest recession in 300 years in the UK. We are the worst hit of our peer group economically, and the government is not going to have spare cash sitting around in the purse to deploy. And so I think the public-private partnership element is going to come so much more to the fore if we're going to harness. And there is a chance that we don't harness everything that we've learned, because we don't have both momentum cash and leadership. But I'm hopeful that maybe there will be a glimmer of hope and there'll be one or two out there who will carry that potential and momentum forward.
I'd like to reference one of the questions here, just for everybody to comment on, and from anonymous attendee, who says, if access to justice was competitive, like other businesses, those wishing for justice will vote with their feet for the service that best meets their needs. At the moment, they don't have the choice as it's a monopoly. So, and the question continues, but that could be a potential solution, bringing in some element of competition. I turn to anybody else for some comments here. Anybody want some predictions?
I'll go next if you like. Well, I think firstly, Dick the Butcher will not be proven to be right. You remember in Shakespeare's Henry VI that Jack Cade was saying, you know, we need to move to a utopian society where everyone lives free and no one needs to worry about the food on their plate. And Dick the Butcher's response was, well, if we want that, first let's kill all the lawyers. And I don't think we're moving into this sort of dystopian world where lawyers and to that extent judges are going to be replaced by technology. But what I do think is that although AI won't kill lawyers, so to speak, lawyers that use AI will succeed much better than lawyers that don't. And that's what I think we'll start to see, that lawyers that embrace technology will start to outperform from a client point of view lawyers that don't. And I think that's where technology, my second prediction, technology will disintermediate the client-lawyer relationship, because technology providers can come in and say, we can significantly reduce the inefficiency of the legal process, be it disputes, contentious or non-contentious, by using technology for document review, for all of those things that you've been paying lawyers for all of these years that you've begrudged paying for. Technology can fill that gap. So that disintermediation by tech, which again will drive the lawyers to adopt tech much better. And the last prediction I've got is that we will move from what I call an ecosystem, which each center, each court, each division of the court, each arbitration center looks at themselves as an ecosystem. It's about them and it's about their delivery, and they're the most important. And we have to move away from that principle into an ecosystem where everybody agrees that what their job is to help the community that they serve. And traditionally, we've had this Garfield approach to evolution. Survival of the fattest has very much been the way in which law firms have developed, and even judiciaries have developed, the Garfield principle of survival. You know, the bigger you are, the more staff you've got, the bigger the budget you've got, the more powerful you are. And we've got to move away from that into the Darwinian principle, where we look at the most agile, the most able to support the community, and they will win out. Question mark, will it be, as Richard Susskind hopes, coming from within the system, or will it be actually led by the private sector, or will it be a synthesis of the two? Well, my prediction is initially it has to come from the private sector because it can be more agile, it can really fill the gap quickly. But actually the critical intersect is when the private sector gets to the point of a decision that needs enforcement, then it needs to go into the state system. And perhaps that's an obvious and natural place for the intersect to be between the private and the public sector. So those are my three predictions.
Christina, do you think that the Law Tech Delivery Panel and all the organisations like that have helped to fill that gap?
Yeah, absolutely. The two government panels that I chair are both very much focused on things that I think will support access to justice and justice tech. And that's about common data standards and data sharing, appropriate data sharing, and where policy and regulation can really help to support consumer confidence, but also to bring in entrepreneurs and to really bring that creative thinking into the justice tech space. And having agreed with everything that Sophia and Mark said, you know, what I would like to see is truly disruptive transformation in this sector. I think it's absolutely right for it. I think it is what justice fundamentally should be about.
the Lord Chief Justice on the 13th of May made it quite clear that there will be no going back to February 2020 in the UK courts. Of that, he said, I am confident. It seems to me, he said, that we have by necessity taken 3 steps forward and done so using poor technology. We will probably take a step back once the pandemic ends. And he says that because he basically went on to say what has happened in the last couple of months demonstrates how vital it is that investment continues. When, as we all hope, the time will come that things are capable of returning to something approaching normal, we won't be back at exactly the same position of having to argue for every penny. Those were his words. And that is where I think we are at in the UK courts at the moment.
And Linda, I'll give you the last word because you're so far ahead. Where do you think globally we're going with our online justice?
I think the future is incredibly positive for Joanna. I think there is groundswell, the appropriate groundswell now, and I think there is no going back. I think there will be some segments who want to go back, but they will realise that the resistance and the pull into lack of productivity and, frankly, non-survival. I think they realise that quite quickly, that is not going to assist them. So I think the international commercial courts are going to lead the way on this. And I think there's a question there in relation to whether or not it would be legal professionals up or the courts down. I think the courts will push it down. I can see that around the world already. I think the lawyers are ready for it. And I think as a collective, that will assist in government, finding resources to the extent obviously it can, but also galvanizing government to do that. So I'm an optimist, maybe because of what we've done, but I think it's time, and I think it's turned. So I think it's more than it's an ignition point now, and I don't think it will burn out. Thanks, John.
Thank you so much to everybody. We've run out of time, and I want to say thanks so much to all of you and such fascinating perspectives. And I hope it's inspired our audience. And I'll pass back to Jasmine now. Thanks so much.
Great. Thank you very much, everyone. I think we can all agree that we couldn't have got a better lineup of fantastic speakers to discuss this topic. So a big thank you to our amazing moderator, Joanna, and our panelists. Just before we wrap up here, round of applause. Just before we wrap up here, I would like to say just a few things. This morning we had the pleasure of the Bahraini Minister of Justice giving us an opening address. However, this was supposed to be live, but it was recorded offline. This is His Excellency Sheikh Khalid bin Ali Al Khalifa, and this will be uploaded offline along with the recording of this webinar, which will be available to you all in due course. Like I said in the chat just now, if you have any questions remaining for the panelists, due to obviously lack of time, please feel free to message us at info@fortemarkets.com and we'll get one of the panelists to maybe get back to you on that. And yeah, we look forward to seeing some of you at our later webinars. If you weren't aware, we have a session today at 2 p.m, which is Women in Legal Tech. So if you are registered for that, Christina will be there. If you are registered for that, then we look forward to seeing you then. However, if you are not and are interested in doing so, you are still able to register via our website, and the link is all over our LinkedIn. So yeah, and we have 2 more days of these webinars. So thank you very much to everyone for kicking off our first day, and we hope to see you soon. Thank you very much, everyone. Bye.